Good evening. This is a webinar in relation to adverse possession. As you know, I'm Edmund Walters. I'm a member of the business and property team at 11 Staple Inn, 42BR barristers, and Stephen Willmer, who's doing this talk with me, and he's here doing the second half of this short talk, and he is also a member of the business and property team. I am a property lawyer, but I also do a lot of regulatory work. In relation to adverse possession, I'm going to concentrate on the basic principles, some of which are really now almost trite law, but to remind you, and some of you may know a lot of this already, but of the basic principles under the old law, what I call the old law, and also what I call the new law, though it's not that new now, in fact, because of course this is the law that derives from the Land Registration Act 2002. The law of adverse possession, and I should say at this stage that we will, after this talk, possibly have a short time for questions. If it's right that we can't answer them, either because they're too difficult or there's not enough time, we will endeavour to answer them by email later, and that might be the best way forward. But you will have a scope to put in questions at the end of both our short talks. Of course, as you know, most of the land in England and Wales is now registered at His Majesty's Land Registry. But any Google will tell you, for example, if you look at a website called whooWnsEngland.org or a quick Google of the AI overview, it will tell you, and the figure comes up again and again, that it's still the case that 15% of the land in England and Wales, that's approximately 5 million acres, remains entirely unregistered. And unregistered land itself can, of course, give rise, as you may know, to bitter and protracted disputes between paper owners and squatters, and can still be fertile ground for both solicitors and barristers in relation to disputes arising about unregistered land. I've had two cases myself, I think, in the last 12 months, specifically about unregistered land, parcels of land between two neighbours in one, a piece of unregistered woodland in the other. So it still makes sense to, and indeed it's still very much current in the sense in relation to registered land, what I describe as the old law. And if I can concentrate on that first, the old law in relation to adverse possession really arises from the law of limitation of actions. And limitation, under the Limitation Act now, and of course it's got a very complex history, the law of limitation in this country, some of you may know about that, but essentially what we have now, of course, is the Limitation Act 1980. And in the usual case of unregistered land, both the remedy and the title of a dispossessed owner of unregistered land are extinguished. And this was the law, indeed, under the predecessors of the Limitation Act, dating back to 1833. But since the coming into force of the Land Registration Act 2002, the prevalence of adverse possession cases has diminished, certainly in relation to registered land. And of course, it must be remembered that under the old law, before the Land Registration Act 2002, it's right to say that of course, the law of limitation of actions applied very much to registered land too. And that's, in a way, there are really three categories of case, which I'm going to consider as briefly as I can in this short talk. Those are cases which involve disputed land which is unregistered, those cases which involve disputed land where there's registered land, but prior to the Land Registration Act 2002 coming into force, there was already a period of adverse possession which satisfied the Limitation Act 1980. And it's right that that in relation to the old law, the possession, of course, is a legal concept, which depends very much on the performance of overt acts and not so much on intention, although I'll come to intention in a moment. And that there's a phrase, possession is a legal concept which depends on the performance of overt acts and not on intention. That comes from the case of Simpson and Fergus from 1999. And for possession to be established, there must, of course, be appropriate degree of physical control of the land in question. There must be single and exclusive possession, although there can be single possession exercised by or on behalf of several persons jointly. And what is an appropriate degree of physical control will depend very much, of course, on the nature of the disputed land. If, for example, it's woodland, as in one of my cases, the degree of physical control required to establish adverse possession may be much less than a piece of garden land, for example. But intention, of course, is also relevant where a squatter claims to have acquired title by adverse possession. But this is an additional requirement approving the factual possession of the land. And I'm not going to dwell too much on case law in this talk, but there are, of course, you may know, two very important cases in this area of the law. One is a more recent case, a House of Lords case of J.A. Pye Oxford Limited against Graham, which you may well know. It's 2003 1 AC 419, which, as a result of that case, many of the principles in relation to adverse possession, which is a concept that, of course, applies to both registered and unregistered land, are now almost settled principles. And that case, that House of Lords case, very much used the judgment of Mr. Justice Slade, as he then was, in the case of Powell against Macfarlane, which is a 1977 case. Powell against Macfarlane, 38 P and CR, Courts 452. And if I can just go to that for very briefly, Powell and Macfarlane was a case of registered land, but under the old law, in fact. And it was the disputed land in that case was an enclosed field, and a 14-year-old boy had the idea of using that land for the purpose of grazing the family cow, which belonged to his grandfather. And he, with the help of friends, did other things. He took out hay from that land and also used it to feed this family cow, which eventually died. And then, as this boy was growing up, shooting was carried out on the land, and various of his friends tethered goats there. But that case, in fact, failed. He applied for adverse possession of that self-enclosed field of agricultural land. But that case failed. But there are a number of passages in the judgment of Mr. Justice Slade, which were quoted directly in the case of Pye, and in relation to the elements which are required to establish adverse possession. And in the case of Pye against Graham, again, this is a case in relation to agricultural land. And in that case, in fact, the squatter effectively succeeded, but only in the House of Lords, and had overturned the decision of the Court of Appeal. But there are a number of passages in that, and I would advise you, if you're going to you have any case about adverse possession, either in relation to registered land or unregistered land, that you look at that case in detail. And I'll give some examples. But for example, in the speech of Lord Hutton, there are a number of quotes from Slade's judgment in that case. For example, the there's a passage, there's an important passage there about a person occupying land, making it clear that they have the requisite intention to possess, and that what conduct should be viewed by the court as establishing that intention. And it's right to say that Lord Hutton in that speech said that he considered that in the normal case, the squatter will not have to adduce additional evidence to establish that he had the intention to possess, because in the case where it is in cases where the acts in relation to the land of a person claiming title by adverse possession are equivocal and are open to more than one interpretation, it may be that those acts are insufficient to establish the intention to possess. But again, he looks very closely at the judgment of Mr. Justice Slade, who said that if the squatter's acts are open to more than one interpretation, and he has not made it perfectly plain to the world at large by his actions or words that he's intended to exclude the owner as best he can, the courts will treat him as not having had the requisite animus possidendi, and consequently as not having dispossessed the owner. And he goes on, Mr. Justice Slade, in that 1977 case, in my judgment, is consistent with the principle as well as authority. The person who originally entered another's land as a trespasser, but later seeks to show that he has dispossessed the owner, should be required to adduce compelling evidence that he had the required animus possidendi in any case where his use of land was equivocal, in the sense that it did not necessarily by itself betoken an intention on his part to claim the land as his own and exclude the true owner. And he went on, again, it's quoted by Lord Hutton in his speech, what is really meant, in my judgment, is that the animus possidendi involves the intention in one's own name and on one's own behalf to exclude the world at large, including the owner with the paper title, if he be not himself the possessor, so far as is reasonably practicable and so far as the process of the law will allow. So all these cases, of course, about adverse possession, and Stephen will obviously be referring to more recent cases, I think cases in the last 10 years, they are all very fact sensitive. And it's right to say that a lot of them do not turn, the more recent cases do not really turn on points of principle, but they turn on the factual matrix of the case and whether or not the person making the claim for adverse possession is able to fulfill that as a matter of fact. Under the law as it was prior to coming into effect of the Land Registration Act 2002, which was on the 13th of October 2003, and that's a crucial date, the provisions of the Limitation Act 1980 applied in the same manner to registered land, as I've said, as unregistered land, except you may remember and you may know that the estate of the registered proprietor, instead of being extinguished at the end of the appropriate limitation period, was deemed by Section 75(1) of the Land Registration Act 1925 to be held on trust for the squatter. And that gave the squatter of registered land the right to apply for registration in place of the existing registered proprietor, and that was under subsection 75(2) of the Land Registration Act 1925. And it's right to say that this form of trust was abolished under the 2002 Act, but you'll need to look at the Schedule 12, paragraph 18(1) of the 2002 Act, which contains, which provides that a squatter who is already a beneficiary under such a trust has a right to be registered as a proprietor. So they're really transitional provisions in Schedule 12, paragraph 18 of the 2002 Act, and they only operate where the land was registered as at the 13th of October 2003. That's the crucial date, the coming into force of the 2002 Act, and that there had been adverse possession for the appropriate limitation period by that date. So that's a category of case, and it's right to say that it does happen on occasions that that an applicant can apply under those transitional provisions, but also under the new provisions of the 2002 Act to be registered with a freehold title of land in which he or she had been in adverse possession. And just going back for a moment to the old law and unregistered land, as you probably know, it's under section 15 of the Limitation Act 1980, which says that no action shall be brought by any person to recover any land after the expiration of 12 years from the date on which the right of action accrued to him, or if it first accrued to some person through whom he claims to that person. So there's this 12-year limitation period, which was obviously and still remains very important for in cases of disputed unregistered land. And so section 17 of the Limitation Act 1980 crucially provides that in a normal case, called a normal case, there are some exceptions, the expiration of that period of 12 years and the title of that person is extinguished. And that's so once extinguished, in the case of unregistered land, the true owner's title is not revived, even if the true owner regains possession. And this is a very different regime from the new regime, which I'll be able to touch on very briefly. And I see that I'll have to be careful to make sure I've got enough time to touch on that. But so under the old law, the way in which it worked was that the squatter, if he fulfilled the requirements of adverse possession, namely the factual possession plus the relevant intention, which is well described in the cases of Powell and Pye, if those are fulfilled, then there's a complete extinguishing of the true or paper owner's title. And the title acquired by the squatter in the case of unregistered land is not governed by statutory provisions. It's governed really by the common law, and what the title is referred to as a possessory title, and it is it's right to say that under the new Act, under the it's not new anymore, but under the 2002 Act, there's a completely altered system, and and you may know what that is, but this derives from recommendations of the Law Commission, Joint Working Group of the Law Commission, and then Her Majesty's Land Registry. There were two reports from 1998 and 2002, which resulted in these changes. And in very general terms, the 2002 Act provides that where the limitation expired on or before the 12th of October 2003, the squatter is entitled to be registered as proprietor under that Schedule 12, paragraph 8 that I've already described. And if the limitation period had not expired by the 13th of October 2003, then from that date, on adverse possession alone, it does not affect the title of registered proprietor to a registered estate. And from the 13th of October 2003, there's no period of limitation under Section 15 of the Limitation Act, which runs against any person other than, in fact, a chargee of a registered estate in relation to an estate of land. So, and the way in which it works, instead, after 10 years, a squatter may apply to be registered as proprietor of the provisions, under the provisions of Section 97 of the 2002 Act and Schedule 6 of the 2002 Act. So it's those provisions that that really govern the situation under this new regime. But if a registered proprietor objects to the application, that will be rejected, save in very limited circumstances, which I'll have a brief time to summarise. But essentially, that the way in which it works is that the squatter does not extinguish the title of the registered proprietor, but the squatter can apply to be registered. But this is often rejected because it is only in very limited circumstances which, if an objection is made, that the squatter can be registered as the registered proprietor. And of course, it must be remembered that under the new Act, it's not the same as in relation to unregistered land. What happens in unregistered land is that the squatter, if the squatter fulfills the relevant requirements and for the limitation period, a new title emerges effectively as a result of adverse possession, which the squatter has and can register. But under the Land Registration Act 2002, if the squatter does fulfil the requirements or get over the obstacles, that squatter effectively is registered with the registered title of the registered owner, and it takes the place of the registered owner, which is a wholly different matter, of course. I can just see the time, but you should, if you want to look at the a good summary of the law, of course, is in the practice guidance, which is issued by the Land Registry. And there are two versions of the practice guidance, one in relation to adverse possession of unregistered land and registered land where a right to be registered was acquired before the 13th of October 2003, and that's practice direction number 5. But there's the practice direction number 4 is the practice direction which governs the situation in relation to registered land. And there's a procedure, of course, and I don't have time to go into the detail of counter notices in relation to an application by a squatter under the 2002 Act. A notice given under that Act really allows 65 working days for a reply, and there's a form NAP which must be used for a counter notice by the registered owner. And if a counter notice is given broadly, it's still possible for the squatter to, on receipt, or when the registrar receives a counter notice stating that the recipient of the notice wishes the application to be dealt with under Schedule 6, paragraph 5 of the Land Registration Act 2002, the squatter can still be registered if one of 3 conditions is met. And you need to look at the detail of Schedule 6, paragraph 5 of the 2002 Act. But essentially, the 3 conditions are that the first one is really in relation to proprietary estoppel. It's the condition can be fulfilled by the squatter, that in the case of proprietary estoppel, making it unconscionable because of that such an equity by estoppel for the registered proprietor to seek to dispossess the squatter. That can be, of course, brought as a separate action anyway, either by way of an action in the county court or indeed the High Court, and it can be an application in its own right, but under this schedule, it is one of the conditions which can apply when a squatter makes an application under this Act. And the condition really is intended to embody those actual principles of proprietary estoppel, which I don't have time to go into, but they're well known. And the squatter, of course, in that situation will have to establish that an equity has arisen in his or her favour. And to that end, they will have to show that they've been encouraged or allowed to believe that they own the land in question. The squatter must have acted to their detriment, and it must be found that it was unconscionable for the proprietor to deny the squatter rights which they believed they had. And of course, any disputes in these cases about adverse possession are often referred by, under Section 73, if there's any dispute arises, of course, they're referred to the first tier tribunal. And a lot of the cases that we now have, of course, are in the first tier tribunal property chamber, and I think the last two I did were both in that chamber. And the second condition under Schedule 6, paragraph 5, is that the squatter, for some other reason, is entitled to be registered as a proprietor. But an example of that might be where the land under the will or intestacy of the squatter is entitled under a will or under the rules of intestacy. But again, that could form the subject of a separate case anyway, or a separate application. And or where a squatter is contracted to buy the land and paid a purchase price. But again, that could be the subject of an entirely separate case. But it can be brought within the umbrella of an application for registration by way of adverse possession. And the third and last condition, and perhaps the most important for practitioners, is in relation really to what are really boundary disputes. And that's where the squatter has been in adverse possession of land adjacent to their own for at least 10 years under the mistaken or but reasonable belief that they're the owner of it. And the exact line of the boundary has not been determined under Section 60. And you may know there's quite a detailed difficult procedure under Section 60 of the Land Registration Act 2002. And for that requirement, that third requirement to be fulfilled, or third obstacle to be got over by the squatter, the estate to which the application relates must be have been registered for more than a year prior to the date of the application. So those are, and for example, an example is always given about this is where there's dividing walls or fences erected in the wrong place, and that's really what that provision or exception is directed at. But again, that could have been the subject of a boundary dispute, separate boundary dispute anyway. But often that is what is relied on, and that I think is the focus of lots of the cases which arise, particularly in the first tier tribunal under this new regime. And there's a provision for, and I think I'm running out of time now, and I will hand over to Stephen, but that in a nutshell is the brief. I think I've got maybe 1 or 2 minutes, but there can be under this, what I call the new regime, if an application has been rejected as a result of a counter notice, and where, for example, none of the 3 conditions which I've just described on paragraph 5 of Schedule 6 apply or are met, the squatter may be able to reapply to be registered, provided they remain in adverse possession for a further 2 years after the date of the rejection. And under these provisions, under the 2002 Act, if there's a period of adverse possession, a further period of 2 years, then the squatter will be entitled to be registered as proprietor, except where they're a defendant in possession proceedings, in which case other provisions, which I don't have time to, under the 2002 Act, which I don't have time to deal with, would apply, and they're not, where there's a judgment for possession given against the squatter in the last 2 years, they're not entitled to reapply, or where they've been evicted pursuant to a judgment for possession. So I think I've covered a lot of ground there. But I would advise you to look at those guidance notes from the land registry. There's also, of course, there are various books, of course, about adverse possession. But there, and in fact, McGarry and Wade have. There's a good chapter in the quite recent book about adverse possession, chapter 10 of that, and there are lots of articles about adverse possession. But as I say, the principles are quite well settled, and in fact, even under the new regime, as I think we'll hear from Stephen, there haven't been a huge number of cases under the provisions of Schedule 6 under the new, which is perhaps surprising. And there's definitely been a reduction in cases, but there are still cases under both the old and the new regime, and it's an interesting area of the law. There's lots more detail I could go into, which, for example, there are cases about easements and whether or not under the new regime it seems to be undecided what happens in relation to easements, whereas under the old regime, for example, you cannot by way of adverse possession have an easement of necessity. So that does sometimes result in cases where you get adverse possession under the old law of a piece of land, but it's effectively landlocked. And of course, that would lead to a settlement, possibly of the case, even if you were an applicant who obtained adverse possession of a landlocked piece of land, it may not be much use to you. But there's a lot more detail I could go into there. But thank you very much for listening. I'll hand over to Stephen.
Thank you. What I'm going to how I'm going to approach this is rather different from what you've heard from Edmund, because I've been looking at cases, and I sort of limited myself to the last 10 years, trying to put some flesh on the bones, really, of the case law that, of the statutory authority that Edmund's been taking us through. And somewhat to my surprise, the quantity of reported cases is actually quite slim. I came up with something like 15 or 16, and very nearly half of those weren't particularly adverse possession based. They were adverse possession cases, but the reason they were reported would have nothing to do with adverse possession. So, unlike, for example, let us say the law of contract, there is not a huge amount on a daily, monthly, or even yearly basis which changes. And so I think possibly the first point I want to make before we start looking at some of the cases which do seem to be relevant is that, as I think has been alluded to already, the law is fairly settled in terms of adverse possession, in terms of the intention to possess, in terms of letting the world know and making sure the world knows that is what you intend to do. But there is an infinite variety of cases which arise out of that in terms of the facts of those cases. And one of the nice things one finds is that actually there's a certain amount of eccentricity which occurs. And some of the cases we're going to hear about in the next few minutes, they concern things like 200-year-old church crypts, or land acquired via fraud, or in one case, land where it literally sat below a longboat on the River Thames, and the question arose there: could the owner of the longboat claim the land which, if you like, was situated beneath his longboat? So the law is fairly settled, but the eccentricities which arise are infinite. They're quite human as well, because it's an area where, if you've ever done any cases concerning adverse possession, an awful lot of the time it's people, not to put too fine a point on it, who are chancing their arm. But equally, there are other cases where people set out their stall, they mark off territory, and they make it perfectly clear that the land which they consider to be theirs is theirs, and they're defying the world to tell them otherwise. Another aspect of the case law, as far as I could think, it's one of the very few, if not the only, cause of action where limitation is the claimant's friend. I can't. I mean, you would normally you would look at a decrepit case, a decrepit cause of action, and say, well, that's fatal to what you want to do. But in the case of adverse possession, very often that's the opposite of the case. That is the opposite of what is true. So it's a quirky, eccentric area of law. And so let's look at some of these cases. There are about 7 or 8 which I've come across in the last 10 years, and which I think I hope will illuminate some of the principles that Edmund has been talking about. This is the case of Best and the Chief Land Registrar, and it's a case which concerns. We're starting out on the eccentric. We have a classic squatter who moves into a home. This was in 1997. It was without the consent of the owner, but to be fair to the squatter, he did some work to make the home habitable. And 4 years, no later than 4 years later, he was treating that home as his own. And in due course, he applied to become the registered proprietor. The land registry rejected his application on the basis that the original act by that squatter had been an act of criminal trespass. So the question which arose was whether or not the squatter was able to benefit from his own criminality. And at first instance, the court held that that adverse possession based on the criminal trespass was not a problem. And this caused a certain amount of difficulty because the land registry, of course, it's a public body, and its concern was not only the integrity of the register, but also the integrity of public policy. And one aspect of public policy is you can't benefit, in most cases, from your own criminal misconduct. So the matter went to the High Court on appeal, and the land registry submitted that adverse possession operated on the basis that the public interest in the use and marketability of land generally outweighed the general concern that somebody should not be able to benefit from what they've done contrary to the criminal law. But in this case, there was a difficulty, and the High Court was asked to adjudicate this problem. And it certainly surprised me that the High Court's view was that whilst, as a general principle, it was undesirable to grant somebody a benefit from their own illegality, there were certainly countervailing public policy concerns, such as in this case, the concern to ensure that a property, that land generally, is being looked after by somebody who takes occupation of it, who invests time in it, who seals it off against the world to ensure that it's not being graffitied, pulled to pieces, and so on. And the result was that the High Court concluded that the squatter, and it's really a classic case of squatting, which, if your memory goes back this far, it's a classic case of somebody who is able to move into a property, whether it's simple land or land plus a building, make something of it, and then to say to the world, this is mine and I'm looking after it. And on this occasion, the High Court was on that person's side. Mendoza is the next case. Sophie, if we could look at that, please. This is the barge case I was mentioning a moment ago, and it concerns somebody who had a longboat, and he asked the land registry to recognize the space, quite literally, the space below the water, if you like, the mud below the water on which his barge was moored, and was moored for something like 13 years, was his. And he'd taken a certain amount. The owner of the barge, or the longboat, had taken a certain amount of care to mark out his territory. And not only had he moored the boat in the same place, um, but there were stones, and there were markings around the I think it's the towpath for aficionados, the towpath um, next to the barge, demonstrating that it was there, and that it was, if you like, an immovable object. The question for the court, I say the court, in fact, it was an upper tribunal case. The question for the court was whether or not, in this instance, 13 years of being moored in that position was capable of demonstrating to the world not only a determination to possess the land below barge, or the longboat, but that the world was on notice of that. It was a highly unusual case. There was nothing like this before the court or the tribunal before this case. The difficulty that the tribunal had, so far as the owner of the barge or the longboat was concerned, was that they didn't have enough evidence to conclude that the owner of the vessel had the requisite intention to possess. He said he'd always wanted to own that strip of the riverbed, and that he didn't want anybody else to have a say-so. But, and this is crucial, the way the tribunal and the court will approach that sort of evidence is with the utmost skepticism. Because obviously the person who is asserting the right to the land, I mean, in this case, it's mud flats below some feet of water. The person who is asserting that right, obviously, is they have a self-interest in advancing what they're saying. In this case, it was a mere say-so. And so the upper tribunal concluded that the boat could plausibly have been moored pursuant to nothing more than a license, or an easement, or some such. But for the owner to establish that it was his land required something more than he was able to demonstrate evidentially. So it's an eccentric case. It's a nice, cute case. But I suppose the point is, if you encounter a situation where somebody is presenting their footprint on public land, or in this case, public water over public land, they're going to need an awful lot of compelling material to show that the rest of the world has been excluded from the location which they're claiming gives rise to a right of adverse possession. Brings us to Sophie, please. Could you move on to the next slide? This is Rashid and Nasrullah. And again, another eccentric, slightly counterintuitive case. It goes against what you would expect the court is going to want to achieve. Now, what happened in Nasrullah was that there was an individual who'd owned some land, and there was a fraud a long time ago. I mean, this case was decided in 2018, but the fraud took place as far back as 1989. And by that fraud, there was a parcel of land which was transferred to an individual, and the um, the respondent in the case was complicit in that fraud. Now, you would think, and I mean, there must be an argument that um, he didn't come to this case with clean hands. But the simple fact of the matter was that his father, who was the principal in the fraud, had conveyed to him, courtesy of that fraud, this land in about 1990. And the owner of the land had done quite simply nothing about it for, what is that, 28 or so years. The point being, somewhat unusually, and I think somewhat at odds with what most of us would expect, that the interest in pursuing the interest that the lawful owner of the land had in ensuring that his dispossession by criminal conduct was not concluded, that interest was not pursued by the owner. And the court's view in Rashid and Nasrullah was, well, fundamentally tough. It was up to you were wronged 28 years previously, but you should have done something about it. And as a result of not doing something about it, the fraudulent conveyance 28 or so years previously was deemed by the Court of Appeal to be valid. Thorpe and Frank, I think, is the next case. Again, a slightly quirky case, this one, but probably more, it's more the sort of case that we're likely to see. Certainly, it's more the sort of case that I routinely see. So it's a case which involved very close neighbors who had to share a paved or tarmacked or concreted area in front of their homes. And many of us will see the arguments arising out of these sorts of cases very frequently. They're bitterly fought. They tend to involve very passive-aggressive behavior surrounding cars and where people park, and so on and so forth. And it's usually these sorts of cases, in my experience, they start out with people being very chummy, but somebody oversteps the mark, and then the neighbor responds in an even more marked and passive-aggressive fashion, and things get very out of hand, and they spiral, and they take years and years to develop and fester. Now, Thorpe and Frank, this is, as you can see, it's a 2019 case, and it's precisely one of these poisonous, very toxic neighbor cases, and again, very ancient, where you had one neighbor treating the driveway as his own. In fact, I think it was her own. And the other neighbor doing absolutely nothing about it for 40 odd years. In fact, in the course of those 40 odd years, the treatment of the driveway, concreting of it, as you can see from the bullet point, it had a further marking of territory imposed upon it by the person who had originally concreted it over. The point about Thorpe, as I read it, is that the Court of Appeal's concern was with the essence of what the type of land was. The dispute between the neighbors was itself fairly routine. It's the sort of thing that one sees over and over again. But the neighbors who had been encroached upon by virtue of the concreting and the cordoning off of this apron of land. When they argued that when they brought this case in 2018, 2019, when they argued that actually very little had happened by virtue of what the neighbors had done, the court's concern was, and its focus was, actually, no, that can't be the case, because you two neighbors, you're living cheek by jowl. And so if your neighbor is treating this piece of land by concreting it over and then in due course by cordoning it off, and you say nothing about it, the Court of Appeal's view was you are actually acquiescing in the conquest of that strip of land by your neighbor. So a brutal lesson, I suppose, from the perspective of the rather passive neighbor in this case. We then have the case of Collingwood. This is a lovely case. This concerns a crypt under a 200-year-old church. I said at the outset that the law tends to be that the law is settled and the cases are fact specific, but time and again one sees these eccentric, peculiar cases, and I think this is the best of the bunch. It concerned a church which was consecrated in about 1840. And for about the next 100 years, the family which had consecrated, it was basically a family church. The family which had consecrated that church had its family members interred in the crypt below the ground level. But about 20 years ago, the church had to be closed. Nobody was looking after it. But in the meantime, the structure, the superstructure above ground, had been bought by somebody else. And the question which arose was whether or not the crypt underneath had been possessed adversely by the purchaser of the superstructure of the church. The difficulty that the acquirer of the superstructure had, among other things, was that evidentially he was unable to show any particular determination to exclude the world from the crypt, or to demonstrate to the world that the crypt, which ultimately was a burial ground for a family going back 200 years, that it was something over which he claimed any kind of right of ownership by virtue of adverse possession. And the result was that the owner of the superstructure, despite asserting nominally a right of adverse possession over the crypt, over the vault beneath the superstructure which he owned, was unable to lay claim to it. Now that was a decision by the upper tribunal rather than by the Court of Appeal. But it seems to me, if you read the case, and it is a nicely eccentric and colourful case, as with the Barge Canal case or Barge River Thames case, what it really demonstrates is that if you have a sincere and a good faith determination to demonstrate to the world that you wish to lay claim to a particular space, whether it's actually a physical building or a plot of land, you really have to go out of your way to do it. It's not good enough to do it in a sort of passive sense. It's not good enough to do it in the hope that somebody is going to notice. Last couple of cases, we have Healy and Frayne, which brings us up to 2023. Now, the point about Healy and Frayne, as you will see, and I'm going to take this fairly shortly because I'm conscious that we are now at 6 o'clock in the evening. Again, you will see this is a decrepit case. I mean, it goes back 40 odd years, and it concerned a lady who owned a property. I think it was her brother from memory who let it out. She wasn't really au fait with what was happening with the occupants of the property, and in due course she sought possession of the property. She owned it, nominally at least, and a variety of defenses to her claim for possession were proffered. There was adverse possession. There was an assertion that work had been done on the property, and that by virtue of proprietary estoppel, the occupiers were entitled to an equitable interest in the property. There was also, and this is the crucial point, there was also the argument by the occupiers that they were present by virtue of a license. The issue for the Court of Appeal, and this is the central point about Healy and Frayne, was this: can you be a licensee and at the same time claim adverse possession? Now, I mean, we're all familiar with the idea, and we all do this, of advancing points in the alternative, advancing arguments in the alternative. But Healy and Frayne is a case where the argument in the alternative, on the one hand, being a licensee, and on the other hand, being an adverse possession, got no ice with the Court of Appeal. It wasn't a case, the Court of Appeal's view was, these are not alternatives, they are simply mutually exclusive. So if you want to argue that you were in adverse possession, you cannot, by the same token, say, as plan B, as it were, well, actually, I was there by virtue of some sort of license. And that brings us to the final case, which is Nazir and Begum, a very recent case, 2024. And the short point about Nazir and Begum is as to whether or not adverse possession can exist where land is subject to a trust. And quite simply, the High Court held that where personal representatives hold land on trust, that is to say, in the event of somebody dying, their role as trustees is distinct, materially distinct, from that of trustees in any other circumstances. And therefore, Nazir and Begum is authority, courtesy of the High Court last year, that adverse possession can subsist, it can exist, it can take place, where you have personal representatives acting in place of somebody who has died. So a canter through 10 years worth of case law, and I'm very conscious at the time. I think we've got some Q&As here. Yeah. So let's just take stock, see where we are. Edmund mentioned the fact the squatter can apply if unsuccessful in the application after 2 years. Is that the case for all cases, old law and the new law, registered and unregistered?
Well, if I can take that one, I think briefly. I mean, how I understand this question is that under the old law, for unregistered land, completely unregistered land, then you can apply on an FR1 form to land registry if you, and it's only really worth applying if you've got evidence that you have been in possession for the relevant period, which is 12 years. And then I don't think there's anything to stop you if one of your applications is rejected in making a further application later. This is in relation to unregistered land. But what I was referring to in relation to that 2-year period is in relation specifically to registered land, where a squatter who who has who fulfills the 10 years applies, there's been a further application can be made. But the 2 year period that I'm talking about is, or further applications, is under the provisions of Schedule 6. It's paragraph 6 of that schedule. We'll have to look at the detail of that. But briefly, if a squatter's application has been rejected as a result of a counter notice being given, there's a form, and none of the 3 conditions which I referred to, which is under paragraph 5 of Schedule 6, are met, then they can, the squatter or the alleged squatter can reapply to be registered as provided they remain in adverse possession. And the phrase adverse possession, of course, and the conditions which I touched on briefly, they're the same for unregistered land and registered land. But this regime here is specifically for registered land after the relevant date of coming into force of the Land Registration Act, and it's there can be a further application by in relation to registered land after two years from the date of the rejection of the previous application. That's under Schedule 6, paragraph 6, and those circumstances, a squatter will be entitled to be registered, except where they're a defendant. But there are provisions which I didn't go into about being a defendant in possession proceedings. That's a whole other area. But again, it's in relation to registered land. So I think what you need to do always in every case is to hold in mind the big difference between when you're dealing with a case where the disputed land is unregistered, just unregistered, that's it, and where the disputed land is registered, whether that's before the relevant date for the 2002 Act, 13th of October 2003, or whether it's before or after that date. So it's the difference between registered and unregistered land. I hope that kind of answers that question. I think there's another one. There's another question, subsidiary questions. Should the owner of land relevant to the claim be approached prior to making an application to HMLR, or should the applicant just proceed with the application and wait for an objection? Now, that is a very general question, but of course, it would be very much tied to the particular case. It may well be that it depends on the weakness of your case. I mean, you have a chance, of course, if you make an application without telling the registered owner that you might slip through the net, and not that they might fail to object to it at all, or file their notice of objection, in which case you're home and dry without having to go through those 3 obstacles or try and overcome any of those 3 obstacles or 3 conditions to meet those after an objection is given. So that might be the scenario, but again, it also might be the scenario, and I'm just making this up, so don't take this as any sort of legal advice, because it is very much dependent. That a registered owner may think that if you've got a really good case, for example, of getting through any of those 3 hoops. I'm just making this up, but if you were able to show that you had a very good case on proprietary estoppel, you might well go to the end and say, look, if I apply to be registered here, I've got the 10 years adverse possession, but I've also got this brilliant case of proprietary estoppel. What do you say about that? I'm going to make this application. Let's save time. You can just agree that. It just depends on the case, doesn't it? And I don't want to make an application if you're prepared to agree that, or we can negotiate that I have some proprietary estoppel claim here that needs to be satisfied. And of course, proprietary estoppel is one where it can be satisfied by different types of satisfaction of your equitable interest, if you like. So anyway, that's
there's a supplementary question, Edmund.
Sorry.
There was no pre-action protocol. No, I don't believe there is, but I think that's the central point. And I was going to actually endorse and ironclad your remarks, Edmund.
Yeah.
I find it hard to imagine circumstances where you wouldn't approach the owner of the land before going to the land registry, because I mean, in many cases, with people living cheek by jowl, they know the answer before they ever apply.
Yeah.
But I'm trying to think of circumstances in which it might not be a good idea to ask or to be seen to be asking, even if you know what the answer is going to be. So I think my inclination would be to ironclad your remarks by saying, make the inquiry, even if you know what the answer is going to be, because at least that way you can demonstrate that you've gone to the lengths of trying to reach agreement before approaching the registry.
Yeah. There was another question, I think, under the new system for unregistered land, where the owner of that land is unknown, and not contesting. How long does the squatter need to show that they have practical possession and intention to possess? Well, that is a classic case, perhaps, of an unregistered land, whether it's not really disputed, but there's a piece of abandoned land, say, on the border of Wales, where no one knows really who the owner is, and it's some old derelict cottage or something in a piece of land, and the neighbours want to get their hands on that. So obviously you can apply. This is again a pure case of unregistered land. So the old system still applies, whereby you have to show this 12 years under Section 15 of the Limitation Act. But the guidance, again, if you go to the guidance, practical guidance or practice guidance given by the Land Registry, you'll see what they say there, which is true, that even if you make an application that's backed up by pretty good evidence, you can still, the class of title you often get initially is only possessory title, registered with possessory title. But the answer is you would make an application if you had a good case that you've been there for 12. And again, this is a case where you would want to be clear what you can prove, and you prove that in evidence in relation to such an application. But that again is not a new system for unregistered land. You say that it's the old system for unregistered land, where it's pure unregistered land, which still applies now. But the way in which it's Practice Guide 5 gives you some help about how you do that, about which form you use. I say FR1, and then the class of title, they say, paragraph 5.4 of that practice guide says, generally, where the application is in respect of unregistered land, we will only register the squatter with an absolute title if we are satisfied that their adverse possession has barred the owner's title. Usually, they say in their guidance, this will only be so where one, we know what the title is. So sometimes in these cases, and I think I've had a case where no one can really get hold of the title, so no one knows what the title is. The title's been lost. People make inquiries, they do all sorts of research, get this, private investigators sometimes involved to find out what the title really is or was. But if it's all lost in the midst of time, and so if they know what the title is and they're satisfied that the owner has consented to or could have no valid grounds for objecting to the squatter being registered as proprietor of the land. In any other case, they say, we will only register with possessory title, and we will not register even with this title in cases of real doubt. In part, they say, this is because where the squatter remains in possession for 12 years, we may convert a possessory title to absolute title. So there's a system of conversion, and that's you should look at Section 62(4) of the Land Registration Act 2002. It's also because we need to bear in mind the owner's rights, they say. It'd be wrong to put the owner to the inconvenience to make an application for alteration. So you may just get that. But I think the point you're making, I think the point I'm making is that the new system for unregistered land, which is highlighted there, it's not really a new system. This is the case under the old system. There's a subsidiary one question there, which I don't quite know. In the scenario where another squatter has blocked their easement to access the squatter one's own property through malice, but now unblock that. And now this is obviously a specific case, and again, I wouldn't want to be offering anything that might resemble any advice, but not in the scenarios they no longer park there. So that looks like a specific case, and I'd be very wary about saying really anything about that. But it's right to say that you do get cases where there are successive squatters, of course, and one squatter can, and that's a whole area of law in the unregistered land scenario, where one squatter two can take advantage of squatter one's occupation, and of course, in the case of unregistered land, you do get squatters doing all sorts of things to each other's claim to that land, if you like, by adverse possession. But I wouldn't like to. I don't quite understand the scenario there. What question is being asked? So I don't think I can take that one any further unless it's clarified. I don't know if there are any more.
I think that's every single one.
Yeah.
We're enjoined, aren't we, to
Yeah,
we're enjoined
to
to point out that the recording will be available shortly.
go.
And thank you very much to everybody for joining us.
Yeah, thank you.
We hope you found it interesting. The recording will be made available. If you'd like to contact Sophie at 42 BR Chambers.
Yes.
I would imagine you've all got her contact details. I don't, Edmund, is there anything you wanted to add?
No, thanks very much for joining. I hope you did find it useful and interesting, to at least to some extent. And also, if you could give us some feedback so that we know what kind of thing you're looking for. And some of those questions, I think, gave some idea that you are obviously involved in cases of this nature, and that this is perhaps a subject that you were quite interested in hearing about. And we could do more, or another one perhaps on some area within this area. We've been quite broad, really, in this short well, it's been longer than we expected, but this short webinar. But if you've got any particular topics in the area of adverse possession, which is a large area, partly because of these different regimes, we'd be interested to hear about that. So thanks very much for coming, or joining rather.
Thank you.
Thank you.
Good night all.